from for Transfer of Property Act, Unit 2, we have these few provisions that we will be discussing. Okay, improvements made by bona fide holder, doctrine of lease pendens, and fraudulent transfer. There are three different concepts. Part performance we have already studied, right? So these concepts are basically based on the concept of equity. That if you have done your part or you are ready to perform your part, then court should allow, right? Court should ask for part performance from the other party as well. Similarly, these also concepts are based mostly on the this right concept of equity, justice, and good conscience only. Right. So first of all, we have this lease pendens. So lease basically means a suit, like litigation we say, right? Like that, lease means a suit and pendens means pending. So lease pendens will mean during pendency of a suit, when a case is being filed in the court and the case is still pending. Under law, right, we have different concepts. Like we have concepts like if a certain case, like there is a concept called res judicata, okay, that if a certain matter is pending before a court of competent jurisdiction, like we have different territorial jurisdiction, pecuniary jurisdiction, subject matter jurisdiction, right? So if a matter is pending before a court of competent jurisdiction, the person should not be allowed to like approach another court, right? Because you are already engaging people over there. So you should not be wasting time of other legal bodies. Let this court decide. If you are not happy with it, you can go for appeal, revision, review whatsoever. But once it's pending in a similar level court, you should not like file multiple cases. That concept is also there, which tries to prevent like multiplicity of cases being filed for the same matter. But what is this concept of lease pendens? It basically tries to do equity for the parties. Okay, so lease means an action or a litigation or a suit. Pendens means which is pending. So lease pendens means during pendency of a suit when the matter is not finally decided. Sometimes when a case is being filed in court, court may provide like some interim reliefs. Okay, like this is not the final judgment, but court has given some reliefs for the parties. It might be that if someone files a case that, like this person, like if you are having doubt with regard to a person's title over a certain property, okay, and you are saying that I don't want to pay rent because this person is not the owner of this property. Now, court would take some time to decide whether this person is owner or not. So court may ask you that until we decide the matter finally, you need to pay the rent because you are staying there in the property. Okay, so that means what? That's an interim relief. For the time being, this relief is given to the owner, that once we decide the matter, then everything will be finalized. But for now, this relief is given. So it does not matter if some interim relief, some in-between things are being done, some injunction order is being passed, that does not matter. We would still consider that this matter is pending. Okay, so during pendency of a case. And the doctrine of lease pendens may be defined as jurisdiction or control that courts have during pendency of action over property involved therein. That means if two parties are approaching the court to decide a certain matter with regard to a property, court is having, okay, so court is having some jurisdiction or control. Okay, court will be having some control over this property, that until this matter is finally decided, you cannot like alienate the property. You cannot transfer the property to someone. You cannot sell the property or stuff, all right? Because it would otherwise be of no use. That court is investing their time deciding the matter and something. Behind their back, parties have already sold the property or something, right? So this concept basically means that court will be having some control over this property until the moment they are deciding on a certain case. So they can put restrictions with regard to it, lease pendens. The principle has been a statutory provision. So under Transfer of Property Act Section 52, this provision is specifically being mentioned. A defendant cannot alienate property during pendency of litigation, venture into depriving the successful plaintiff to the fruits of a decree. So who will file the case basically? Plaintiff, who is victim of the case, right? So plaintiff is asking for some sort of relief, remedy, some sort of declaration from court. That is the reason why defendant would be restricted from alienating the property, transferring the property to someone else. Like for this time being, you need to wait for court to decide the matter. Once this matter is being decided, then you will be free to do whatever you want, because otherwise this order would be of no use, right? Whatever court finally decides, that will be of no use. So that is the reason why we basically have this concept. So there was this case wherein it said that this concept, right, concept of lease pendens, it would plainly be impossible that any action or suit can be brought to a successful termination if alienations, pendenture, light were to be allowed to prevail. So if you are allowing that, okay, fine, you can alienate properties, you can transfer properties even when the case is pending, then this entire thing of filing a case or bringing an action would not make any sense, because who is going to follow this order of court ultimately, right? If you are no more, you know, like owner or no more liable or no more parties to the property, then this decision that court would give, that itself would have like no meaning.